Good morning, everyone. I'm Kimberly Chalia with PHCA. Thank you so much for joining today's webinar, Part 2, Nursing Facility Requirements and Participation Phase 3, part of the three-part webinar series, How to Survive the New Normal, presented by Paula Sanders herself. A few quick updates before we get started today. This webinar is being recorded and will be made available on the PHCA website. The webinar has been approved for 1.5 continuing education credits for all attendees. For those who provided a NAB number, credits will be uploaded shortly. We'll also share certificates as well as the presentation with those in attendance. As we begin today, all attendees will be in listen-only mode. Please feel free to submit your questions via the Q&A icon on your screen, and we'll make sure to answer as many of those questions as possible at the end of today's presentation. I'll turn it over to Paula.
Thanks so much, Kim, and good morning, everybody. I hope you're ready for another wild ride through the new requirement of participation, interpretive guidelines. Today, we're going to be focusing specifically on 2 areas, the freedom from abuse, neglect, and exploitation, and the quality assurance and performance improvement, or QAPI or QAPI changes. We're also going to touch in between on issues related to grievances and how they intertwine with this. But I really want to spend a lot of time, probably more on talking to you about the abuse and neglect changes, a little bit less on the QAPI. So I think QAPI in and of itself is a very technical area and worthy of a presentation on its own, whereas the changes dealing with abuse and neglect are going to have, I believe, a much more immediate impact on your staff and your day-to-day activities. CMS made changes in 5 F tags under abuse and neglect, F600, 604, 607. They took 608 and split it in half between 607 and 609. Well, I'll go through some of those changes. And with respect to QAPI, they took 866, relocated it to F867. And then we have additional information and requirements under F865 and 868. But let's turn first, just some basics. The definition of abuse at the federal level has not changed. It still requires some sort of willful infliction of injury. And that willfulness means that the person had to have acted deliberately, not that they intended to inflict injury or harm. And keep in mind, as we go through this, that instances of abuse, irrespective of their physical or mental condition, causes some sort of physical harm, pain, or mental anguish. And there are various types of abuse that we'll be touching on: verbal abuse, sexual abuse, physical abuse, and mental abuse. That piece hasn't changed, but what they did do is expanded neglect, right? So what you see before you on these slides, the red in this case is language that was added to the State Operations Manual. Neglect is the failure of the facility, its employees, or service providers to provide goods and services to a resident that are necessary to avoid physical harm, pain, mental anguish, or emotional distress. It occurs when the facility is aware of, or should have been aware of, goods or services that a resident requires, but the facility fails to provide, that has resulted or may result in physical harm, pain, mental anguish, or emotional distress. It includes cases where the facility's indifference or disregard for resident care, comfort, or safety resulted in, or could have resulted in, physical harm, pain, mental anguish, or emotional distress. It can be the result of a pattern of failures, or it may be the result of one or more failures involving one resident and one staff person. And we'll get back to this theme, but I wanted you to have this language in front of you, particularly when you go back to your centers and start looking at your policies and procedures, as these themes are going to start coming through, especially when we're going to talk about emotional distress. For the most part, historically in Pennsylvania, if you've been cited under F600, we call it the abuse tag, right? But now CMS is directing the surveyors and the survey process to distinguish much more carefully between abuse and neglect. And then we're going to look at some changes that CMS made to resident abuse. They've instructed the surveyors, and I think this is a good thing, to say, you know, not every altercation between residents is abuse. And they give an example. Infrequent arguments or disagreements that occur during the course of normal social interactions, like dinner table discussions, that would not constitute abuse necessarily, right? The surveyor has to determine whether the incident meets the definition of abuse. So we go back to that definition that's on that first slide, and that's what the surveyors are going to be picking apart for resident abuse. But I think it's important for CMS to have really taken the time to point out that not every incident between residents is an F600 citation. Additionally, CMS realized that the SOM guidance that's in effect right now goes farther than the regulation allows them to. So they have removed the sentence that said residents without the capacity to consent to sexual activity may not engage in sexual activity. CMS determined, properly so, that this wrongly suggested that all residents without the capacity to consent are not allowed to have any physical intimacy. Instead, they pointed out issues where it's a per se, meaning an automatic sexual abuse, and that's if the contact is not consensual, if the victim is sedated, temporarily unconscious, or in a coma. For other residents who are engaging in sexual activity, you're going to be responsible to taking steps to ensure that the resident is protected from abuse. And that means you need to evaluate whether the resident has the capacity to consent to sexual activity. All of the other language with respect to sexual intimacy between residents remains the same in the state operations manual, including the provision that says powers of attorney, for instance, don't have the authority to make this determination on behalf of a resident if that power is not granted to them. So you're really going to have to look carefully, work with your social services team and your behavioral health team and your physicians to determine whether the residents actually have the capacity to consent. Do they understand what the activity is? Are they able to describe it and discuss it with you? That would be an indication that they probably have some capacity to consent to that activity. Where we're going to spend some time today talking in a few minutes is on this reasonable person standard. So under the resident to resident abuse, CMS has said, if one resident abuses another, if a reasonable person would likely suffer actual harm as a result of the incident, and that's actual psychosocial harm, the incident will not be cited below actual harm. So when we're talking actual harm, that's GHI, right? The scope and severity. G, isolated actual harm. H is a pattern, and I is widespread, and then we have immediate jeopardy, right? So what they're saying here is if there's resident-to-resident abuse that's verified, you're not going to get a D, an E, or an F, right? If the reasonable person would likely have suffered actual harm, they're going to cite you at a G or above. Now, under the F600 tag, the CMS has instructed the surveyors to look for past noncompliance, but they're told they should investigate each instance thoroughly to determine if the facility took all appropriate actions to correct the noncompliance, and then determine the date on which the facility returned to substantial compliance. Before we discuss it, let me tell you that even though you believe you may have corrected the deficiency and that the surveyor should cite you for past noncompliance, they are not required to do so. And if you continue to believe rightfully that you have demonstrated past noncompliance, you're going to want to file an independent dispute resolution, an IDR, seeking that past noncompliance. But just because the surveyors are now being told in the SOM to look for this, does not mean that they're required to grant you past noncompliance. The three elements of past noncompliance, the first one is sort of obvious, that you weren't in compliance with the regulatory requirement at the time the situation occurred. And the non-compliance occurred after the last standard survey and before the current survey. And that current survey could be a standard survey, a complaint survey, or a revisit, right? Those are pretty obvious. The third one, and this is where we get hung up a lot, is whether there's sufficient evidence that you corrected the noncompliance and you're in substantial compliance at the time of the specific, at the time of the current survey. And we're hearing all sorts of reasons why the state is not awarding past noncompliance. A lot of it falls into two buckets, if you will. The first bucket being that you haven't trained enough people on whatever the incident is that you're implementing your corrective action for. And the second one, which is a little bit more specious, I believe, is that there hasn't been enough time for you to demonstrate your auditing and monitoring to prevent the noncompliance. But I don't want to spend a lot of time talking about past noncompliance right now, but if anyone has questions about it, certainly shoot them and we can touch on them at the end of the presentation today. With respect to showing corrective measures for abuse, right? If you have an abusive situation, immediately protect the residents from additional abuse. Make sure you're assessing the victim as well as removing the alleged perpetrator. If you have an allegation that an aide has engaged in some sort of physical or mental or sexual abuse with a resident, removing them means taking them out of the building or putting them someplace in a non-resident care area. Don't move them to another wing because the state's going to say that's not protecting people sufficiently. Take steps to prevent further abuse. And you'll note here what I've put in red is directions to the surveyors, right? We're under F600, but they're going to be directing the surveyors to say, okay, if you don't think they've taken steps to prevent further potential abuse, look to cite them as well. You know, are we compliant at F610? Make sure you report the alleged violation and investigate within the required timeframes. And if not, the surveyors are going to cite you at 600 and 609. Conduct a thorough investigation of the alleged violation, F610. Take appropriate corrective action, F610. And make sure that you're revising the resident's care plan if the residence needs change, and that's F656. And why am I putting this here? We're seeing a lot of what look like duplicative citations, right? We're getting cited one event under multiple tags, and it's clear in the abuse area. I'm using this as the example to show you how the state surveyors are being told by CMS, these are the areas you want to look at immediately when we're talking about abuse. What we should be seeing in the 2567s, but what's not always clear, is the second citation. How, if they're just cutting, if they do a cut and paste from the F600 tag, it's not clear always how that constitutes a deficiency under 609 or 610, for example. So it would be something worth IDRing, right? If you're getting a duplicative citation with nothing that ties the second violation into the requirements of the regulation, you should look to file an IDR on that issue. But I do want to pause here and talk about the residence care plan if the residence needs change. This is a pitfall that folks encounter, particularly when a resident is having behavioral issues and is the instigator of some sort of alleged resident-to-resident altercation. You know, wandering residents who are annoying other inhabitants, for instance. So you can see that cross-reference there. And it's important as you look at doing your abuse investigations that you also are looking to link care plan changes to potential abusive situations. So this new focus on neglect that's clear in the revised state operations manual, they're looking at neglect as the cumulative effect of different individual failures in the provision of care and services by staff that leads to an environment that promotes neglect. The state operations manual goes on to say that neglect occurs when the facility is aware of or should have been aware of goods or services that a resident requires, but the facility fails to provide, resulting in or that may result in physical harm, pain, mental anguish, or emotional distress. They give a new example of a neglect tag under F600. Failure to implement an effective communication system across all shifts for communicating necessary care and information between staff, practitioners, and resident representatives. How often have you found yourself in a situation where you come in on a Monday and you find out that something happened on the 11 to 7 shift on Saturday and nobody communicated that through, and here you are now Monday morning trying to find out exactly what happened. This will also play in to what we'll talk about towards the end of today's presentation, which is the important role that your QAPI program is going to play in helping to ensure these effective communication systems exist. A lot of times you're having these discussions about very sensitive cases in the moment, whether it's at stand-up or in safety huddles, but that's not being documented and it might not necessarily be communicated across all shifts. So look at what you're doing right, those in the moment instances, and start thinking about how you're going to capture that, document it, and show that information is being communicated across shifts and between staff, and especially with the practitioners, whether it's your physicians or your physician assistants or nurse practitioners, as well as the resident representatives. But in terms of that immediate care issue, I think it's really important when we're talking about the abuse and neglect to make sure that you're really capturing those in the moment issues that I know you're all working on when they occur. Now, the really good news, I think probably about the only good thing I'm going to tell you about this morning, is that CMS has come out directly and said F600 should not be an automatic citation. And they give two examples, one relating to F686, which is pressure ulcers, and F689, accidents and supervision. And CMS has said, listen, just because you've had something happen at 686 or a fall or a failure to follow a care plan, that does not automatically indicate facility noncompliance at F600. So the example with skin assessments, you failed to perform skin assessments, which resulted in the failure to implement interventions to prevent a stage 2 pressure ulcer. You eventually implement the interventions. You're going to get cited, obviously, at F686 for failure to prevent pressure ulcers. But it does not automatically mean that you're going to get cited under F600. The other example is staff who fail to provide supervision to a resident who falls, right? How many of us have seen that 689 G tag because a resident failed to follow a care plan and the resident fell, resulting in a broken arm, right? We used to say it's an automatic 689 at a scope and severity of G, isolated actual harm. But then Pennsylvania was citing people by saying, well, the failure to follow a care plan is an automatic citation. So we were getting hit at both 689 and 600 for abuse. Remember, Pennsylvania, and most states, weren't really distinguishing between the abuse and the neglect, right? But the citation for neglect, and this is really important what CMS is saying here, the citation for neglect would require additional evidence that identifies that the facility knew or should have known to provide the staff, supplies, services, policies, training, or staff supervision and oversight to meet the resident's need, but continued to fail to take action necessary to avoid the potential for harm or actual harm to the resident. So this is going to let us get credit, if you will, for those instances where you can show you train the resident, you train the CNA. The CNA knows where the Cardex is. The CNA knew what the care plan said. And for whatever reason, they ignored their training, they ignored the policies, they ignored all the documentation that said somebody's a 2-person assist, and went ahead and it did something that resulted in harm to the resident. You're probably still going to get that 689 tag, but you're not going to get that second, or you shouldn't get that second F600, sort of that piggyback. If you can show that you as the facility were doing what you needed to do and that this was an isolated staff failure. So I think this is a great change that we're looking at from CMS. And as I mentioned or alluded to just a few minutes ago, there's going to be new language on the 2567 for an F600 citation. One, if they're citing you for abuse, it's going to say, based on observations, interviews, record review, the facility failed to protect the resident's right to be free from. And then they're going to have to identify the type of abuse and say who the perpetrator was, right? By a staff, a resident, a visitor. If they're going to cite you for neglect, they're going to say the same thing, but they're going to say specifically that the facility failed to protect the resident's right to be free from neglect. So they're teasing this out, making it much more specific, which I think would be a good thing. Unfortunately, what I didn't see is any change in the policy that if you are cited for F600, depending on your history and the scope and severity, the likelihood that you're going to get that red hand stop sign on the Medicare Compare site. Just something to keep an eye on. And now we spend a lot of time, probably the next half hour or so, talking about the new psychosocial outcome severity grid, because the surveyors are directed to this reasonable person concept when they're looking for psychosocial or emotional harm. So what does that mean? They're supposed to ask, what degree of actual or potential harm would somebody expect a reasonable person in the resident's similar situation to suffer as a result of the noncompliance? What are they supposed to consider? I mean, what does this mean? So they start from a couple premises, right? The resident considers the facility to be their home, where there's an expectation that he or she is safe, has privacy, and will be treated with respect and dignity. So keep that home concept in your head. The second consideration is that the resident trusts and relies on staff to meet their needs, right? So we've got, this is my home. I expect to be safe. I expect to have privacy, and I expect to be treated with respect and dignity. And I trust the people who work in the facility, and I'm relying on them to meet my needs. Additionally, I may be frail and vulnerable. So that's the reasonable person. It's not what does a reasonable person on the street, right? It's what would a reasonable person in a resident's similar situation experience? You know, what are their expectations? And what kind of harm, psychosocial or emotional harm, could they suffer? Additionally, the psychosocial harm may not be readily apparent. For example, the resident might be unable to express themselves due to their medical condition and or a cognitive impairment. They may not be able to recall what occurred. They may not even be expressing any outward signs of physical harm, pain, or mental anguish. Just because it's not readily apparent, the SOM is telling the surveyors, again, when you see my reds and in quotes like this, directly out of the SOM. However, when a nursing home resident is treated in any manner that does not uphold a resident's sense of self-worth and individuality, it dehumanizes the resident and creates an environment that perpetuates a disrespectful and or potentially abusive situation for the residents. So what does that mean? It means that the surveyors are being told there are certain issues where you're supposed to look for immediate jeopardy for psychosocial harm caused by potential abuse. And these include sexual assault, such as rape, unwanted sexual touching, that could cause a citation for immediate jeopardy, sexual harassment, any staff to resident physical, sexual, or mental or verbal abuse. So you may get tagged and see the wording of the deficiencies are going to change a little bit. Now, the state operations manual does note that if the employee has a pre-existing and consensual sexual relationship with an individual who is then admitted to the facility, that would not constitute sexual abuse unless there are concerns about the relationship not being consensual. But otherwise, we're looking in the column on the left at immediate jeopardy, citation for psychosocial harm. Additionally, surveyors are told to look for psychosocial harm at the IJ level if staff post or share demeaning or humiliating photographs or videos of the residents. When staff, as punishment, threaten to take away residents' rights, privileges, or preferred activities, or withhold care from the residents. We could have double things going on in these examples, right? Because you've got that abuse, but now we're also looking at evaluating what kind of harm is coming from that. And there's this presumption now that this harm is at an immediate jeopardy level. Likewise, any resident-to-resident physical abuse that is likely to result in fear or anxiety. Let's pause as you're taking that in. I'll give you some examples out of the state operations manual. I think these examples are wonderful training tools. Remember that you have to be training your staff about recognizing and preventing abuse and neglect. And your CNAs need to understand this. And I think some of these examples will hit a chord, as I have seen examples of almost all of these, some of them very recently. So let's look at this first one. How do we get to immediate jeopardy for psychosocial harm related to sexual abuse? The staff find resident 1 in resident 2's bedroom holding resident 2, whose clothes have been partly removed and her breasts were exposed. R2 has significant and severe cognitive impairment. R1 had a known history of sexually inappropriate behaviors, but there was no evidence that the facility had assessed and revised his care plan to identify potential risks to other residents related to his behaviors. So a couple of things here, good takeaways, right? R1, history of sexual inappropriate behaviors. What's his care plan say? Not much. It may say that, we're going to redirect him, but this takes it a step further and say, what are the potential risks to other residents? So if you do have someone who has sexually inappropriate behaviors, you want to make sure that the care plan not only talks about addressing his behavior as against himself, but also what you're doing for other residents in the building. Now, I mentioned before that R2 had severe cognitive impairment. There was no evidence that resident 2 could consent to sexual activity with other residents. The facility reports this, and the surveyors interview R2's daughter, who not surprisingly says she's shocked and talks about how her mother would have been upset if her mother knew what was going on. And the conclusion: because this type of inappropriate, unwanted sexual contact would reasonably cause anyone to have psychosocial harm, it can be determined that the reasonable person in the resident's position would have experienced severe psychosocial harm, dehumanization, and humiliation as a result of the sexual abuse. So you're going to see language like that in this F600 for the sexual resident-to-resident sexual abuse. It's not only going to talk about the abuse, the sexually inappropriate touching, but it's also going to draw this conclusion based on this reasonable person standard that a reasonable person in the resident's position would have experienced, and note this language, severe psychosocial harm, dehumanization, and humiliation as a result of the sexual abuse. We have another example. This one is an immediate jeopardy for psychosocial harm resulting from physical abuse. This is a real interesting one. In resident R1, he required one-to-one supervision due to his physical aggression. He was observed to have escalating behaviors, which resulted in his striking out at staff and residents in the vicinity. The allegation is that staff failed to ensure that residents in the vicinity were safe. R1 pushed R2, who was walking to her room while unsupervised by staff, as described by housekeeping staff who witnessed the incident, right? So you've got R1, unprovoked, pushes R2, she falls to the floor, gets a fracture that required treatment at the hospital, placement of a cast, and was in moderate pain due to the fracture. You might say, well, Paula, that's a G, right? I failed to supervise and it's actual harm. How do you get immediate jeopardy out of that? And here's how they do it. Again, in red, right from the State Operations Manual. Even though there was no significant decline in mental or physical functioning, it can be determined that the reasonable person would have experienced severe psychosocial harm as a result of the physical abuse, since a reasonable person would not expect to be injured in this manner in his or her own home or a healthcare facility. So remember when we started this discussion about psychosocial harm, and I talked about the consideration being that residents consider the facility to be their home, the analysis then says, okay, would a reasonable person expect to be pushed over in their home? No. Therefore, that person would experience severe psychosocial harm. And even though there is no indication here that there was any decline other than the broken arm and the cast, moderate pain, not immediate jeopardy, we don't have significant decline in the mental or physical functioning, they go further and say, what would that reasonable person, what would that person think? How would they feel? And we've got immediate jeopardy for this incident. We might even have immediate jeopardy, even if R1 was being supervised, right? So we're looking at different, this whole new layer that's being put over what we've come to expect with result to scope and severity and assessing degrees of harm. Well, go look at this next one. I think this has more resonance. The allegation begins with that the facility deprived residents of care related to the failure of staff to respond timely to residents' requests and treat residents with dignity and respect, which resulted in ongoing embarrassment, humiliation, and the failure to provide incontinence care as needed to meet the needs of several residents. So surveyors come in, and as you know, they talk to families and they do resident group interviews. And both the families and the residents complained that residents often waited a long time, up to an hour, before staff took them to the bathroom, resulting in residents urinating in their beds and lying in urine for long periods of time. Residents further went on to tell the surveyors that this is a problem, especially on the night shift. And the residents told the surveyors that they had been told by nurse aides to just urinate on their beds, and staff would change the sheets in the morning. 2 night shift staff members confirmed that they had seen other staff functioning. In this example, we're already getting cited for noncompliance at dignity, which is F550, and urinary incontinence at F690. But we're now going to get 100. After investigation, it was determined that the nursing failed to provide the necessary care. It can be determined that the reasonable person in the resident's position would have experienced severe psychosocial harm, example, embarrassment and humiliation as a result of this abuse. So an immediate jeopardy that is occurring in more facilities across the country than we can think about. But look how they've converted this, right? You've already gotten a tag for dignity. You've gotten that tag on urinary incontinence. And those were probably maybe a G. But now we're coming in and saying we're in immediate jeopardy because of the severe psychosocial harm caused by this non-compliance. Here's another example. The facility deprived resident 1 of care by failing to provide access for communication and response to resident 1's request for necessary care, resulting in resident 1's ongoing fear and anxiety. You love this, right? During the surveyor sees that R1's call light was pinned to a privacy curtain that was out of reach of R1. R1 told the surveyor that the staff removes the call light at night because they say he uses it too much and they don't have time to answer the light all the time. During the conversation with the surveyor, R1 began crying and expressed fear that something would happen and he would have no way of getting assistance as staff would not come if he called out for help. Immediate jeopardy. Based on the resident's behavior, it can be determined that the resident experienced severe psychosocial harm as a result of the deprivation of care. So you put these two, the moving the call bell and not providing incontinence care timely, the surveyor interviews, the way the surveyors are going to ask questions. And I'm sure there are a couple of you who are thinking come October 24th, you're going to have to do something with your staff because there's a high likelihood of immediate jeopardy for the psychosocial harm that this reasonable person concept has started now to weave through other deficiencies. Because these two that we're talking about right now, not that unusual, right? You've all seen it at some point in your careers. So what are we going to do about it? And how are we going to really get the staff to up their game? Because now those, delay in responding to call bells, if you've got a weepy resident, you're looking at immediate jeopardy there. So something to absorb. I like using the examples from the State Operations Manual because they're real. These are actual examples, and I think they're relatable for your staff. Here's actual harm, resident-to-resident abuse. First allegation, we failed to protect R2 from physical abuse when R1 slapped R2 in the face. Based on resident and staff interviews, R1 had previously exhibited an aggressive tone towards other residents. Based on the interview with the nurse aide, R2, right, R2 is the victim, was talking loudly to R1 in the hallway. R1 shouted a profanity to R2, followed by, "If you say one more word, you're going to be sorry." Very plausible event. The nurse aide is on the hall. She witnesses this. She's the only person there. She was transferring another resident. She couldn't intervene, and she didn't call for assistance from any other staff. R2 continued to talk loudly, and R1 then reached out, slapped R2 on the left side of his face, and backed his wheelchair away from R2, right? Left the area. R2 was immediately assessed. His left cheek exhibited some signs of redness in the area that was slapped, and this is an immediate assessment. No other physical injuries, and that red area goes away pretty quickly. It's recorded, right? You do your incident report. So the surveyor comes in and they interview R1, who had recall of the incident, and said, "R2 just won't stop talking. I don't know what came over me." So R1 confirms that this happened. R2 was moderately cognitively impaired, couldn't recall the incident. What would you say without reading the end of the slide? You'd probably try to argue for a D, right? Potential for actual harm. Maybe a G, although it's sort of hard to say that that's serious harm, right? A slap on the face. The surveyor calls R2's son and asks about the incident. And the son says, "My dad would have been really mad after an incident like this." So what does the SOM say? Therefore, by using the reasonable person concept, the survey team would conclude that resident 2 would have experienced psychosocial harm, for example, anger directed at the action or at a person, as a result of the physical abuse, since there is an expectation that the resident would not be slapped in the face in the facility. So that D, which we would have argued that was a D, right, is now a G. Good news is not immediate jeopardy, but you can see how this reasonable person concept gets colored by what's your expectation if you're in your own home, right? This expectation that I'm in my own home, I wouldn't expect to be slapped in the face. I got slapped in the face, I'd be angry. If I'm angry, that's actual psychosocial harm. So playing these couple of examples, I want you to just start getting a sense for how the survey is going to change, right? We're so key to looking for, was that resident harmed? I can't tell you how many facilities would look at that and say, okay, some redness didn't go to the hospital, didn't require any first aid, didn't require any intervention other than to be separated. And now here I am looking at an actual harm. Hopefully some people have questions on that, but let's move on in the interest of time to F604. F604 deals with restraints as abuse, and they've added clarification about when a bed rail is a restraint. And it's a restraint when it keeps a resident from voluntarily getting out of bed in a safe manner due to his or her physical or cognitive inability to lower the bed rail independently. That's the one addition that CMS made to how bed rails can be restraints. Everything else regarding bed rails has not changed. So if you're using them, you want to make sure you're measuring the mattress every year and doing everything else that we've been doing since the regulations came out. F607, develop and implement policies and procedures for abuse and neglect. Couple things to note here. Develop and implement written policies and procedures, right? A lot of you have procedures, they're not written, about the posting of notices, right? For 607, the state's going to want to see your policies and procedures as well as the postings, right? And that's got to be a conspicuous notice, the same size as your other employee-related notices. And that notice, which is posted in an area where your staff is going to see it, is going to talk about prohibiting and preventing retaliation against employees who report abuse, as well as the employee's right to file a complaint with the state and how they can go about filing those complaints about retaliation. This section came from F608, but I want to draw your attention to it because we're seeing a lot of citations as we want to talk about grievances as well. States are finding huge lapses in posting of notice and giving notice to residents, families, and staff about their rights to file grievances. And here we have now this addition of the posting of employee rights as well. Additionally, with respect to your abuse and neglect policies, you have to establish a linkage with your QAPI program. How are your cases being communicated to your QAPI program? I had mentioned earlier that many of you, when there are suspected instances of abuse or neglect or serious injury, you're immediately convening safety huddles. How's that information coming back? Can you set up a subcommittee within your QAPI program that's going to be responsive to doing these immediate investigations and reporting back to the QAPI program? And that's going to show the involvement, that linkage there. Keep in mind that cases of physical or sexual abuse always are going to require a corrective action plan and tracking within the QAPI program. But I do want you to start thinking, as I mentioned earlier, how are we documenting those great things we're doing at the immediate moment when some of this stuff is going on in our buildings? So not only do I want you to think about that upfront activity, but then how is information getting communicated back to QAPI? Something to think about here. So F607, who's covered, right? CMS says the facility cannot disown the acts of its staff, since the facility relies on them to meet the Medicare and Medicaid requirements for participation by providing care in a safe environment. Staff includes employees, your medical director, consultants, contractors, volunteers, caregivers who provide care and services to residents on behalf of the facility, students in nurse aid training programs, and students from affiliated academic institutions, including therapy, social, and activities programs. So when we're talking about staff that has to know things with respect to your abuse and neglect policies, it's a huge group of people. In addition, 607 talks not just about the reporting of abuse and neglect, but also about the reporting of a reasonable belief that a crime has occurred under the Elder Justice Act. And that reasonable belief of a crime has to involve either a resident or a person receiving care from the facility. Who's required to report those? those are covered individuals. And covered individuals are defined as the owner, operator, employee, manager, agent, or contractor of the facility. So keep that list in mind, because we're going to be talking about this two different things as we go forward. F607 also distinguishes employee screening, right? So if you're going to get tagged under 607, it's because you don't have policies that have been implemented related to screening procedures prior to employment. 606 talks about the fact that you can't employ or engage an individual either directly or under contract who was found guilty by court of law of abuse, neglect, misappropriation of property, exploitation or mistreatment, or concerning abuse, neglect, mistreatment of residents, or misappropriation of resident property. And I've put misappropriation of property in italics there because oftentimes when you're looking and doing those criminal background checks, you'll see that somebody has been convicted of some sort of theft. Under the federal law, you're not supposed to employ or engage them, either directly or under contract. We're also seeing, with respect to employee screening, lots of citations coming in for failure to screen contracted employees or contractors, like you don't have proof of the hospice people who are coming into your building. So you want to take a look at those policies and procedures. F607 also provides new investigative protocols for the surveyors. They're going to be doing the observations to make sure you have the appropriate postings up. If there was allegations of retaliation, if you retaliated against somebody for reporting a suspected abuse or neglect, surveyors may be reaching out to the state professional licensing authorities to see if you have filed a complaint against your staff. They're going to interview staff, they're going to interview the administrator, and they're also going to be looking at employee personnel records for evidence of retaliation. And those could be, job changes could be considered to be retaliation. So we're seeing this new emphasis or re-emphasis, if you will, on this anti-retaliation and postings. 607 also talks about the failure to report an Elder Justice Act crime. So if the surveyor discovers that there was a reasonable suspicion of a crime committed against a resident or an individual receiving services from the facility, right? So first they discover this reasonable suspicion of a crime. Then they see that it hasn't been reported by a covered individual. The surveyor is going to remind the facility of the covered individual's obligation to report suspected crimes within the required timeframes. If the covered individual says they reported the suspected crime to local law enforcement, the surveyors are supposed to verify that the report was made. For example, obtain the time or date of the report, the name of the person who received the report, and the case number. If the covered individual refuses to report, or the surveyor can't verify that a report was done, the surveyor has to call his or her supervisor immediately, and the state agency has to report the potential criminal incident to law enforcement immediately. F609 talks about your responsibilities as a facility to annually notify covered individuals of their reporting obligation to comply with the Elder Justice Act reporting requirements to state agencies and local law enforcement. And that report has to be made if there's serious bodily injury, no later than 2 hours after they formed the suspicion of a crime against a resident or individual receiving care from the facility, and no later than 24 hours if the event did not result in serious bodily injury. They define a serious bodily injury as an injury involving extreme physical pain, involving substantial risk of death, involving protracted loss or impairment of the function of a bodily member, organ, or mental faculty, requiring medical intervention such as surgery, hospitalization, or physical rehabilitation, or an injury resulting from criminal sexual abuse. So we've talked about the reporting of a reasonable suspicion of a crime, but we also have obligations to report allegations of alleged violations. An alleged violation is a situation or occurrence that is observed or reported by staff, resident, relative, visitor, another healthcare provider, or others, but hasn't been investigated, and if verified, could be noncompliance related to mistreatment, exploitation, neglect, or abuse, including injuries of unknown origin and misappropriation of resident property. Huge expansion here. Now, CMS has gone on to define injuries of unknown source with relation to when they're required to be reported. All three of the following criteria have to be met. The source of the injury was not observed by any person, and the resident could not explain the source of the injury, and the injury is suspicious because of the extent of the injury or the location of the injury. For example, the injury is located in an area not generally vulnerable to trauma, or the number of injuries observed at one particular point in time, or the incidence of injuries over time creates a suspicion. So in a minute, we're going to talk about the timeframes for reporting these allegations. But CMS has really gone out of its way to make sure that facilities remember that if we're dealing with a potential crime, they expect you to, be CSI here, right? Exercise caution when handling materials that may be used for evidence or for a criminal investigation. They report that they've heard reports that some investigations were impeded due to washing linens or clothing, destroying documentation, bathing or cleaning the resident before the resident has been examined, or failing to transfer a resident to the emergency room for examination, including obtaining a rape kit if appropriate. So, things to keep in mind if you suspect that there has been some sort of criminal activity. Try and preserve the scene as much as possible. So this is a CMS chart, the timelines for reporting. And it distinguishes between the timelines under the Elder Justice Act and the timelines under the regs, the other regs relating to abuse, neglect, exploitation, or mistreatment, including injuries of unknown source and misappropriation of resident property, right? So under the Elder Justice Act, you have to report any reasonable suspicion of a crime against a resident or an individual receiving care from the facility. That report has to be made by any covered individual, which means the owner, report operator, employee, manager, agent, or contractor of the facility. And the Elder Justice Act allegations that reasonable suspicion gets reported to the state survey agency and one or more law enforcement entities. It goes on to say, when is that supposed to be reported? If it's a serious bodily injury, immediately, but not later than 2 hours after forming the suspicion. And if it's not serious bodily injury, not later than 24 hours. But CMS has gone on to say, we're not talking business days, we're talking clock time. So if this happens at 2 in the morning and there's a serious bodily injury and there's a reasonable suspicion of crime against the resident or an individual receiving care from that facility, under the Elder Justice Act, that report has to be made to law enforcement within 2 hours. Not later than 24 hours if there's no serious bodily injury, but there's a suspicion of a crime. Under the regular, I would call regular is probably a poor choice of words, under the abuse neglect reporting, all allegations, all alleged violations have to be reported, as well as the results of the investigations of the alleged violations. This is an obligation of the facility as opposed to a covered individual. And the violation has to be reported to the administrator and to other officials in accordance with state law, including to the state survey agency and the Adult Protective Services, where state law provides for jurisdiction in long-term care facilities. When all alleged violations within not later than 2 hours, immediately but not later than 2 hours, if the alleged violations involves abuse. People miss that all the time, right? If you got an allegation of abuse, that's supposed to be reported within 2 hours. Or if there's an alleged violation that resulted in about something that resulted in serious bodily injury, that's within 2 hours. Not later than 24 hours if the alleged violation involves neglect, exploitation, mistreatment, or misappropriation of resident property and does not result in serious bodily injury. We're not doing a great job as an industry in making these reports timely. Additionally, people overlook the fact that the regulation talks about the reporting of alleged violations, not substantiated violations. And one of the things we see constantly is facilities discounting the allegation, not doing an investigation because they don't believe the resident. You have to report it anyway, and you have to investigate it, right? So every allegation, I like to say, you have to assume it's true and prove it's false. And if you start from that premise that every allegation is true and your job is to prove that it's false, you'll get in the habit of investigating and reporting all alleged violations. The CMS also lists the kind of actions they expect your policies to address. Top one, and where we fail frequently, is orienting new and temporary agency contractor staff to the reporting requirements. Assuring that covered individuals are annually notified of their responsibilities. Identifying barriers to reporting. Identifying which cases of abuse, neglect, and exploitation might rise to a level of a potential suspicion of a crime. Recognizing the physical as well as the psychosocial indicators of abuse, neglect, and exploitation. Working with law enforcement annually to determine which crimes are reported. Assuring that covered individuals can identify what's reportable with competency testing or knowledge checks. Providing in-service training when covered individuals indicate they don't understand the reporting responsibilities. And this one was a surprise to me. Providing periodic drills across all levels of staff, across all shifts, to assure that covered individuals understand the reporting requirements. The penalties for failure to report under the Elder Justice Act, the civil money penalty of not more than $200,000 as adjusted annually by the CMP inflation factor that we've talked about before, and possible exclusion. If the failure to report exacerbates the harm to the victim or results in harm to another individual, that covered individual is looking at a civil money penalty of not more than $300,000 as adjusted and possible exclusion from the federal health care programs. How are you going to prove that you're doing your annual notification? Make sure you're documenting. CMS will accept a copy of a notice or letter sent to covered individuals with confirmation that it was received. Note that, not the confirmation that it was mailed, but confirmation that it was received, as well as a completed training or orientation attendance sheet documenting the individual completed training on reporting obligations. In addition, if you look at the end of F609, they give a lot of examples, which would be very good depending on your individual needs for training, about staff to resident abuse, resident to resident altercations, injuries of unknown origin, potential neglect, misappropriation of resident property, and exploitation. And the examples go through this is something that should be reported, this is something that doesn't need to be reported. We could spend another hour talking about those examples. I just want to direct your attention to F609. If you've got questions in these particular areas, that would be a good place to look at. And now, as I said, we're doing sort of a short shrift, if you will, to QAPI. There's an awful lot to cover with QAPI. One of the big changes in terms of the implementation schedule now is that the surveyors are going to verify that the governing body has oversight of the QAPI program. They do recognize that some small facilities may not have a traditional governing body, meaning like a board of directors, and the governing body can include individuals such as the facility's owners, chief executive officers, or other individuals who are legally responsible to establish and implement policies regarding the facility's management and operations. You should make sure that you have a policy that indicates the purpose of the program that's been approved by the governing body. And those things need to include such elements as ensuring current and evidence-based practice standards, that the policy is designed to prevent deviation from care processes, that your goal is to identify issues and concerns with systems and to identify opportunities for improvement, and to develop and implement plans to correct and improve identified areas. Demonstration of compliance with your QAPI plan is going to include, but it's not limited to, showing evidence of systems and reports demonstrating the identification, reporting, investigation, analysis, and prevention of adverse events, data collection and analysis at regular interviews, documentation of corrective actions or performance improvement activities, and upon request, you have to present evidence to the surveyors, including documentation of your ongoing QAPI program's implementation and compliance with the QAPI requirements, recognizing the tension between this because the internal workings of your QAPI program are still confidential. So there is a tension here, but there is an expectation that you're going to be able to give evidence that you have a plan and that it's working. Your governing body has a couple things that they have to make sure that the QAPI program is doing, right? Because they're responsible for overseeing it. They need to make sure that the program's defined, implemented, and ongoing, that addresses identified priorities, that it's sustained through transitions in leadership and staffing. We see a lot of breakdown, when there's turnover in these leadership positions. They also have to make sure the QAPI program has adequate resources, including staff time, equipment, and technical training as needed. Also, they have to ensure that the QAPI program is using performance indicator data, resident and staff input, and other information to identify and prioritize problems and opportunities, that it's implementing corrective actions to address gaps in the system, and that it's evaluating actions for effectiveness. Most importantly, the governing body has to make sure that program is establishing clear expectations around safety, quality, resident rights, choice, and resident respect. You also want to make sure that you have written policies for feedback and input from direct care staff, other staff, residents, and representatives. How are you getting that information? Not only do you have to indicate how you're getting it, you're going to have something that shows how you're using that information from direct care staff and others to identify high-risk volume issues or problem-prone areas and opportunities for improvement. And then you have to have effective systems to identify, collect, and use data and information from all departments. You want to make sure as well that you're looking at the development, monitoring, and evaluation of performance indicators, including the methodology and frequency for such development, monitoring, and evaluation, and that you're monitoring adverse events, systematically identifying, reporting, tracking, investigating, analyzing, and using data to prevent adverse events. Other considerations, are you evaluating the implementation to include the identified methodology for data assessment, analysis, and root cause approaches for adverse events? Make sure you're reviewing your policies to ensure they contain how you're getting that feedback, as I mentioned, key point, from residents, responsible parties, and staff. How you're collecting it, frequency of monitoring, key program elements such as your systemic approaches to root cause, developments of these corrective action plans, performance indicators, and methods used to identify trends. Use your minutes and your forms as tools, right? There should be some standing agenda items. Make sure that you're getting attendance and sign-in sheets, signed, dated, and indicating the titles or positions of the attendees. You can also use that if you're having frontline staff at some of these meetings, because that will demonstrate one way that you're obtaining input from staff. You want to make sure your minutes are addressing things like outcome measures, analysis of trending, how improvement is sustained. And I'd have a standing agenda item on prior survey deficiencies to show how they're addressed, monitored, and remain in compliance. Assure that your documentation of your performance improvement activities and outcome monitoring is demonstrating ongoing improvement, right? So you want to have all of those things. Some other considerations to use those forms is make sure you include a report from your infection preventionist, and we'll talk about that momentarily. Some other considerations would make sure that you have a method to document your annual risk assessment to validate how performance improvement activities were selected for high risk, high volume, and problem areas. I would make sure you include at least quarterly a discussion. Do we need to be updating our facility assessment? As I had mentioned at the last webinar, I think the facility assessment is going to be a key tool for what the surveyors are going to be looking at to monitor compliance across the broad spectrum of the new regulations. Make sure that your QAPI plan addresses adverse events as well as medication errors and drug reduction, looking at tracking, trending, causes, and prevention approaches. Validate that you've completed at least one performance improvement plan that was identified through data analysis and includes the following elements, right? A team interdisciplinary approach, concentrated efforts over time, a focus on a systemic problem with a root cause analysis that demonstrates the effectiveness of interventions and or revisions to interventions based on identified cause with monitoring of outcomes and analytics. When you're thinking about your QAPI committee, remember you've got to meet quarterly, at least quarterly. You've got to be reporting to the governing body, and your members have to include the director of nursing, your medical director or a designee, at least 3 other members of the facility staff, at least one of whom must be the administrator, owner, a board member, or other leadership person, and your infection preventionist. For the infection preventionist, or at least one of the individuals, if there's more than one infection preventionist, has got to be a member of the committee, and they have to report to the committee on the infection prevention and control program on a regular basis. Regular basis means that that reporting should occur at the same frequency as the meetings occur. When I talk about standing agenda items, this is one I'd want to see so you don't forget it, right? Because this is low-hanging fruit. I want to make sure if I'm the surveyor, I'm looking at your minutes to see how frequently are you meeting. Do you have a sign-in sheet that's going to tell me that all of these people were there? Otherwise, I'm going to cite you under F688. I'm sorry, 868. And finally, I see we're getting close. We're trying to save some time for questions. Keep in mind that there's also a new requirement under F944 for QAPI training. Your program has got to include mandatory training that outlines and informs staff on the elements and goals of the facility's QAPI program. The training has to go to staff, contracted staff, and volunteers if consistent with the volunteer's expected role. And you should be validating that 100% of your staff has completed that training. Also keep in mind, and one of the things we'll be talking about at our next webinar is what are these new training requirements? So we'll talk at some length about various issues that have to be addressed, including training on the Elder Justice Act requirements and abuse, neglect, exploitation, and misappropriation of resident property. So what's next? Implementation of the phase 3 guidance is October 24th, which should be, I believe, a month from yesterday. Our next webinar on the requirements of participation, the third in the series, is August 30th. And we'll be doing a wind-up overview at the convention September 13, 2022. And with that, Kim, I'll turn it over, turn this back to you if there are any questions.
Thanks, Paula. Yep, just as a reminder, if anyone has any questions, please submit those utilizing the Q&A icon at the bottom of your screen. I do see, it looks like Karen submitted a question in the chat. Paula, do you see that comment?
I don't. Let me see if I can. You just pull, see if I can get to the chat. I am not seeing the chat. I see the Q&A, but not the chat. Can you read me what her question is?
Karen said, what are the surveyors looking for communication to Board of Director for QAPI?
It's a great question. I'm not really sure exactly what they're looking for. Obviously, you don't want to turn over your entire QAPI minutes to the board because that's not privileged, and you don't want that as an attachment. I would consider a high-level summary showing proof that the QAPI committee is meeting. And I would look as well for a statement from the governing body that they are reviewing the QAPI committee operations. One thing that some facilities are doing when they have a large governing body is including as a standing agenda item on the board side report from the QAPI committee. And that could be a simple report coming from the administrator or the director of nursing or somebody else to the governing body saying at a very, very high level, because you don't want them in the weeds, you know, here are some of the things that we're tracking. And I hope that helps.
Thanks, Paula. I don't see any additional questions in in the chat. If anyone does have any additional questions that come up after today's session, please feel free to reach out to Paula or myself. And again, thank you so much, Paula, for sharing this important information today. I look forward to seeing everyone at next week's part 3.
Thanks, everybody.
Thank you.